Okay, thank you very much. All right, so I'll start again. I think Bashan is absent. Falmouth?
Here.
Hartston?
Here.
Kirkmeyer?
Here.
Sarouche?
Here.
And Spiro?
Here.
Okay, and I can see if we have any members of the public. Want to join. Oh, good, and Sharon's here now too. So we're all here. That's good. And there's only one attendee at the moment. So if you would like to make a comment, you can raise your hand in Zoom. Otherwise, and I don't see a raised hand. So if you want, we can go ahead and get started. And today I can just start really quickly with sharing. I think there's just two topics that we're hoping to cover today. One is this consideration of proposed disciplinary standards. And the next one is, we have an outstanding item having to do with public records and that consideration. So we can come back to the slideshow when we talk about public records, but for now, I'd like to turn this over to Brady and maybe Carissa to talk about the disciplinary standards.
Sure. Hi, everybody. I didn't know if you have all met Carissa Andreessen. I realized I've never actually said your last name, Carissa. Did I get it right?
You did, Andreessen.
And Carissa does a lot of work for the Office of General Counsel in relation to discipline, and our office represents the State Bar when proceedings go to the Supreme Court beyond the State Bar Court. So she handles that and our second review look at discipline. So she's very experienced in this area, and she was the one who prepared the draft standards for paraprofessional discipline, which were circulated to you guys a few weeks ago. And I think Carissa is just going to give an overview, and then we can discuss those. We have a couple of changes that we have noticed that we will make as we go, I think two, and then there are probably 6 or 7 additional issues that we have for discussion, all but one of which were shared with you in the memo. So I'll let Carissa start. Do you want me to share the Word document, or what do you think is best, Carissa?
I think that might make sense if one of us wants to do it. Do you want to go ahead?
Sure, I can do that.
Okay. And while you're pulling that up, let me say, yesterday I had some internet issues, so my video was cutting in and out. If you guys have any problems, I'll just,
We are. You want to turn out your video?
turn up my video off and on.
And sorry to interrupt. Did you say Carolyn is on the discipline committee? Because I see her as an attendee.
I don't think she is.
She's not.
Okay, thanks.
Okay, Brady, are we ready?
Yes.
Okay, so I did go ahead and shut my video off just because it seems like my audio is not coming through.
We can hear you great now.
Okay, cool. So the standards for the licensed paraprofessional sanctions for professional misconduct were drafted essentially using the attorney standards as a model. So the document that Brady pulled up here is essentially the standards for attorney sanctions with the appropriate modifications to conform to the licensed paraprofessional scheme. And essentially what these standards are is to sort of set a base for determining the appropriate disciplinary sanction where a paraprofessional is found culpable for misconduct. And so it's kind of a base starting point based on the particular violation at issue. And then it can be adjusted to greater discipline or lesser discipline, depending on the circumstances, including certain aggravating factors, certain mitigating factors. And the idea here is to kind of ensure consistency across the imposition of discipline for different paraprofessionals. And at least in the attorney scheme, these standards were developed based not only on the rules of professional conduct, but also disciplinary case law, statutes, state bar court decisions, Supreme Court decisions. And so to that extent, those are sort of captured for the paraprofessional scheme. And generally speaking, in the attorney world, the Supreme Court typically will accept a recommendation for a level of discipline consistent with these standards, except to the extent that it has some sort of grave doubts as to whether it's appropriate in those circumstances. So just that's a little bit as a background. I'm happy to go through each one of them, or if it makes more sense, we can just open it up to questions. Brady, do you have a preference?
Probably, I would think that given their basis on the attorney standards, it might make sense to go to questions. We do need to revisit 2.8, which deals with 5.4. Leah with Eagle Eyes this morning noted that it's not quite consistent with the paraprofessional rule 5.4. So I have a few suggestions for editing this right on the screen before we finalize it as a recommendation. But I think it probably makes sense setting that aside to take questions, because again, these are based on the attorney standards. So any appropriate departure, I think would come from ideas or questions from you folks on the committees. Unless anybody would prefer to go through them one by one. I think Julianne had her hand up first.
Thanks. Yeah, I noticed, or I assumed that these standards for paraprofessionals are based on the attorney standards. I'm looking at 2.12, which has been deleted entirely. Why was that done?
2.12.
2.12.
Okay, let's get there.
I had the same question too, Julie.
Oh,
I'm sorry, 2.
Violations of oath or duties.
Yes, that's the one.
Okay, Brady, feel free to correct me. These were, I'm assuming, removed because it refers specifically to a statute, the Business and Professions Code, section 6068, that it would apply specifically to attorney misconduct and lay out the duties of an attorney. Now, Brady, were these deleted because, I don't recall this, were these deleted because this statute is not going to extend to be made applicable to licensed paraprofessionals?
That's not clear. I think the deletion came from you, but these are matched to the conduct in the code, and I guess this goes to a larger issue that these standards do recommend disbarment in some cases. For the attorney scheme, disbarment is not permissible for violations of the Code of Professional Conduct for attorneys. So in order to implement these draft standards, either the legislature will need to, enact statutory provisions that make disbarable all the same conduct for paraprofessionals as is mentioned in the code, or authorize disbarment as a sanction for violation of the Paraprofessional Code of Conduct. that's really sort of an implementation question. Whereas these standards are basically saying, here's the result for these various categories of misconduct. Here's what we think should result, and then it will be up to the legislature and the court as to how exactly to get there. But we didn't read these as, because it's not clear that any of these 68 statutory provisions for attorneys will apply to paraprofessionals. We did not include these. But all of this is covered in the other rules, correct, Carissa, as far as the substantive things that a paraprofessional should or should not do.
Right. Most of these duties are covered by the rules of professional conduct for the licensed paraprofessionals, which are based on the attorney ones. The sort of the difference in the attorney scheme, as Brady was explaining, the greater levels of discipline have to be charged as violations of the Business and Professions Code. So any suspension greater than 2 years or disbarment has to be based on a violation of the Business and Professions Code duty. And so that sort of helps explain why for the attorney scheme, these same duties are in the Business and Professions Code as well as in the rules of professional conduct. And I think there's other instances where we have removed references to Business and Professions Code provisions that apply specifically to attorneys, since they're, as far as I'm aware, these are not going to be made applicable to licensed paraprofessionals. But yes, Brady, the conduct is covered.
We don't know. So basically, these are trying to work within the universe of recommendations that we've already made. If that makes sense. Julianne, did you have another?
No, that's fine. I would think, though, that the legislature might enact some law specifying the duties of a paraprofessional. And so obviously you would want to revisit these standards to substitute in that code section.
Right.
I was just wondering why it was deleted entirely, but I see.
Amos?
Yeah, so let me just ask a follow-up question there, but then I have my own. I assume we could take a different approach, which is to allow discipline to include quote unquote disbarment or suspension longer than 2 years for violation of the paraprofessional rules of professional conduct. And we could do that by specifying that in these rules, as well as potentially court rules as well, right? So there is no state bar act for paraprofessionals. So I think at least on the regulation subcommittee, we did take that approach. I mean, obviously not for disbarment, but we decided to incorporate things like prohibitions on running and capping or requirement for written agreement that are included in the State Bar Act or in the Business and Professions Code for attorneys. So I at least think it's an open question that we could decide on a different approach to that.
Right, certainly. But these, as written, these do cover, I mean, they're mostly written without reference to a specific rule or statute, but to a specific type of misbehavior. And currently, all we have making those types of misconduct illegal for paraprofessionals is our code of conduct for paraprofessionals. So that code of conduct plus these draft rules will say, for X violation, which is barred by the code of conduct, disbarment is allowed. And then to get there, as a matter of implementation, we will either need the legislature to pass the individual laws and duties for paraprofessionals, or to say, hey, disbarment is available as a punishment for violation of the paraprofessional code.
Sorry, so I think I lost the track there. I guess my question is, could we, if we wanted to, allow the option of taking away the license of a paraprofessional? I won't call it disbarment, but it's just for technical reasons, but but not allowing a paraprofessional to continue to practice under a license as a potential remedy for discipline
Yeah.
without statute.
Yes, I mean, I guess that either the court or the legislature would need to recognize that that's a potential remedy for violation of the rules. The way this is currently written is we're saying, for this substantive misconduct, here's where you should have your license taken away. Here's where you should be suspended. And then we get there one of those two ways.
Right. Okay. Sorry for the digression. My comment has to do with 2.10. So unauthorized practice of law. It looks like because this tracks the attorney rules, it doesn't contemplate practice beyond the license. And I wonder if that should be included.
Oh, so you mean because they are only entitled to a limited practice if they engage in anything that's beyond that scope, it should be included in this rule. The language should
Correct.
capture that. Okay.
If they are practicing law in an area that is not permitted because of their limited license.
I mean, isn't that, I guess I sort of read it as, it is unauthorized to practice. You are engaged in the unauthorized practice of law if you're practicing beyond your license, but I could see you want to suggest specific language.
So here, as I read this, it's not in the definition. So these are defined as unauthorized practice of law if they unlawfully hold themselves out as entitled to practice while they are on suspension for disciplinary rules, or and I think the B talks about, licensed in a different jurisdiction. So as I read it, although I say I read it quickly, my understanding, my read of this didn't include practice of law beyond the limited license. Again, I think that would be a crime, right? I think that would be, there is a statute that I think would cover that. It seems like it should be included here as well.
Yeah. And what do we think would be the presumed sanction?
So in other words, does it go in A or B?
Yeah,
Or
so just
you're creating a C? Mhm.
I was creating a C, but I mean that's up for discussion.
So this is up for discussion, but it seems like it fits within the definition of A.
Right.
So I mean, we would have to add it to be specifically covered, but I think it is similar to the things that are in A.
And
Yeah.
Brady, what I would say is if you look in the second sentence there, or the second line rather of A, engages in the unauthorized practice of law. It's that term that I think maybe we just need to expand upon. But if they practice beyond the scope of their license, that is the unauthorized practice of law, because it's beyond the scope of their license. And so maybe it just entails further defining what unauthorized practice of law in this context means.
But maybe it could just be a reference to the relevant rule, because we're pretty explicit about that in the rules.
Yeah.
But why do you say, Amos, it's more akin to A? Because
It is the unauthorized practice. It is the unauthorized practice of law, as I think Carissa was just explaining. I think technically it might be included there already. It's just wasn't clear to me when I read it.
Okay, but this is UPL when you're already on suspension.
It's both. So it's either engaging in the unauthorized practice of law or holding yourself out as entitled.
Got it. Sorry.
But that is the part that wasn't clear to me as well. Yes.
Oh.
And you might arguably, I mean, maybe it's captured by the last sentence here, but once you get into beyond the scope of his or her license, there will be some degrees, obviously. There will likely be some gray areas that will only be developed through practice as far as, we have some very black letter lines that they're not supposed to cross, but there might be some gray areas. And I suppose that's taken in with the degree of sanction. on whether or not they knew or should have known.
No, I actually think it goes in both. I mean, because you could do B too, right? As outside of your scope. Because it's tied to the second part of it. Like, right? So it's while he or she is on actual suspension or disciplinary reasons in the jurisdiction. And then this one, because it's the different levels of what happens based on certain circumstances, right? Certain criteria. Because a person could be on voluntary inactive status. That's what kind of the difference is, and practice outside their scope. I think I mean, I had the same question, Amos, about I didn't know if this covered. It looked like it could, but it just wasn't clear. But I think it would go in both sections
So
if we're
is
going to
the-
clarify it.
And
I
is
think
the
I agree
exam-
with that, yeah.
Yeah, I think that's right too. And an example might be if a paraprofessional does not complete their bond or have the right bond, right? I assume there's going to be some, involuntary, status change.
Late fees.
Right, but also would be, limit their ability to practice law. So if they're doing their normal practice in that status, that might be different than if they're practicing beyond their license in a different area, right?
Right, which is sort of why I don't see how it falls into B, because B is talking more about sort of the engaging when you're not technically allowed to versus.
So just
Sorry,
beyond
Kimberly.
that. Yeah, I think you're right, Brady. I agree. I know what you're saying. Because we need to make the definition. Do we think that it fits into disbarment and actual suspension for that? You could do it in both. You could be on some other status, but the importance is how important do we think it is? Should it just fit in A?
Well, on B, it's almost like you're doing, if we put that, if you're engaged in beyond the scope of practice and you're in the B situation where you're, on voluntary inactive, or, you've got some, you didn't pay your fees, so you're moved to inactive status. You're sort of doing two things wrong, because one is the technical thing addressed by B, two is the thing you shouldn't be doing at all, which is practicing beyond your license.
Correct, but isn't it possible you're doing one or the other? What I'm saying, certainly it's
Right.
possible you're doing both, but what if
That's
you're
why you
just-
only needed an A, I think.
Oh, got it. Okay, yeah. that makes
I
sense.
agree. Because that's where it would start, no matter what status you were in, if you were practicing outside your scope.
And my next question, are people done with that? Because I have a unrelated.
Let's, should we see what Ira had to say?
Yeah, I don't think that practicing beyond the scope should be one of the disbarment or actual suspension should be the presumed sanction for that. And the reason I say it is that some of the scopes are kind of vague or so close to something. Some of the scopes are so close to something that's not in the scope that it's probably difficult to figure it out in a lot of cases. And that doesn't mean there shouldn't be discipline or there shouldn't be disbarment or suspension. But I do think it means that disbarment and suspension should not be the presumed sanction.
Well, this is, and again, and maybe we do need to see, because A is talking about engages in the unauthorized practice of law, which includes practice while they're on actual suspension for disciplinary reasons.
Yeah. I'm talking about the blue addition there.
Yeah, but that still only applies. You have to read the whole sentence. I mean, this neither of these, even for attorneys, is talking about, I mean, let's take a step back.
What about the whole
For
sentence?
attorneys, this isn't talking at all about an unlicensed person who engages in the unauthorized practice of law, because they can't be disbarred or suspended. They're just not licensed. So, this is a good discussion to have, because I think arguably we do need a 3. which talks about, in the absence of anything else, whether there's on actual suspension or not, which is what A deals with for disciplinary reasons. If somebody is just accused of practicing beyond the scope of their license, what then is the
Yeah,
is the recommended?
Brady,
But
I'm saying that the blue practice beyond the scope of the license, disbarment or actual suspension shouldn't be the presumed sanction.
But that's saying, but if you keep reading an A, it's when they are already on actual suspension for disciplinary reasons.
Where does it say that?
No, I thought that's what I thought. And then Amos and Chris have clarified that it's not.
No, it's all ors in that clause.
Well, I think for applying this to paraprofessionals, it's unclear. And that's why I thought this needed to be clarified. Because I agree, it reads differently if it's an attorney if they're an attorney, there's no areas of law that are technically out of bounds. So I mean, it can be done either by modifying A or by adding a C, but I think it needs to be changed.
But I mean, if you took out what I wrote, there's no commas there. So it's, if you engage in the unauthorized practice of law or unlawfully hold yourself out as entitled to practice law while you're on suspension or involuntary active. So.
Yeah, but what does that
so-
modify? You can't tell. You
Yeah,
can't
so-
tell.
Brady, I think I
Modified.
agree with you because that's the reason we have an A and a B. The first one is if it's for disciplinary reasons, B is for non-disciplinary reasons. But I think you're right. Each one of them is going to depend on what status you have, not just whether you engaged in UPL. It's UPL,
Right.
this status, it's UPL on this other status. So Leah, I take back what I said before with respect to your question. I do think that that's the intention here in the attorney sanction world.
I think you need another one. I think you need a 2.11 or 2.10A or whatever it would be to say going beyond your scope as a separate issue, because you could do these just like an attorney if you were in these other statuses, but you could also work beyond your scope. So I think you need another one.
That's all I was going to say too. I think you need a C to cover unauthorized practice by a paraprofessional, either because they're outside the scope of the license that they've been given, or as Amos said, if you don't maintain the right bond or the appropriate bond, the required bond.
Well, that would fall already, I think, within B, right?
Well, I don't know. It talks about non-payment of fees.
Well, it says holds himself out as entitled to practice law while he or she is not licensed, but maybe it could say is not entitled to practice law, because that's what the bond would. If you failed to adhere to your bond requirement, you wouldn't be entitled.
I have a general comment on these paragraphs. They're awful hard to read. I realize that's the way they appear for lawyers, but shouldn't they be broken down into subparagraphs like suspension or removal is the presumed sanction when a lawyer : A, B, C, D. So you don't have to be searching for the ors and the ands. It's awful rough to do that. That's why I see what you're saying about paragraph A, Brady, but you have to get to the end of the long sentence to see that it's limited to that situation at the end.
You guys want to talk about how we should, while I figure out the words here, what the presumed sanction should be?
I was just going to say, Ira, there's a concurrent effort underway right now through the Ad Hoc Commission on the Discipline System that I think is going to result in some changes to these standards. And as I was reviewing them, I was thinking about anticipating those changes in this document, but I think that makes it too complicated. So I almost feel like for now we take the basically the structure of the lawyer standards, including, verbiage that may not be perfect, with an understanding that the oversight committee may in fact revise these standards pursuant to changes that are made on the attorney side.
So when we were talking about it under A, I didn't go further into detail, but if it's going to be C, and by the way, we might want to put it first because I think this is the bigger issue. So to make it A, I think disbarment is the right. And this is
Well,
the
if it's
biggest
knowing, isn't it? Isn't that if it's knowing, really? Because if it's
that's fine. I mean, this is the presumed, right? So if it's not knowing, obviously it's not a required sanction, but this is, I think, is one of the bigger risks, right? That you have a limited license and you have somebody out there practicing beyond the license. And I think the remedy should be to take the license away in those situations where it's, as you say, if it's reached the level of discipline and sanctions for that, this is really where the rubber meets the road on regulation of the system for people who are not staying within their license.
about like a lesser degree of sanction may be appropriate if the licensed paraprofessional did not know. I mean, I think you have knowing, you have should have known, and then you have probably some areas where the rules just aren't clear yet, where it's,
So I do think that's what should have known is supposed to cover. So should have known might be a, not a bright line rule, and you apply it, depending on the state of the law or the state of the trainings. But the whole point here is this is supposed to be a limited license, and it is important to know what a paraprofessional can and can't do. So claiming ignorance, I don't think should be enough. I think it's no or should have known standard. Again, just a presumptive sanction. You can always, it's not a required sanction, right?
okay. And the paraprofessional knew or should have known that he or she was practicing beyond the scope.
I actually think if an attorney can get disbarment or actual suspension for working on a suspended license,
Okay,
that this should say disbarment or actual suspension. Because they could be suspended for a year or something and not actual
Yeah.
disbarment. I think this just actual disbarment only is too.
I agree too.
I agree with Kim.
great.
Can I raise a unrelated, well, actually related, but not directly the same point, maybe much easier, especially if this is something that discipline has already talked about. And it's use of the term disbarment. So
Right.
I see that it is a defined term that does apply as defined, but I'm not sure.
Do you,
I could see a different approach. I could see the bar adopting a different term for paraprofessionals. And I think I would prefer a different term, and I think it might be,
License revocation.
something like that. Yeah. So I don't know how significant it is, because it is defined in a way that applies, but I don't know how many changes would be required, but hopefully it's just a search and replace.
Right. I mean, on the one hand, they are practicing law, so they are at the bar, but I see what you mean for clarity's sake.
Yeah, I think I agree with that, Brady.
What, you agree with making the change now, or
Well, I don't know if we need to make the change now, like while everybody's watching, but come up with a change and make it throughout.
okay.
Yeah, like license revocation.
Just as
Is that-
context, we do use revocation. That's for all of our licenses.
Okay, we will find change license revocation throughout.
That makes me ask a question, what you were talking about earlier about, disbarment and what's authorized versus the rules versus what statute is needed. And would it just need like a section in the statute kind of that says discipline for, the paraprofessionals is all of the following, like revocation, suspension, public reproval? Is that kind of how it would be listed out?
Yeah, I mean, it's hard to say, and this is Greg might be able to offer a little bit more clarity. And once these recommendations are made, it could go any number of ways. I mean, I think as a practical matter, we need buy-in from the legislature and the court, but technically the court has the authority over licensure to practice law, so it could all come from a court rule, but that's just not the way it's done for attorneys.
Okay.
Is that sort of would you agree with that characterization, Greg?
And are we talking about just the earlier standard that we were discussing for violations of the State Bar Act?
Well, just how it would be, how this would be authorized.
The standards themselves?
I think,
Right.
Greg, I think, Greg, the remedy of license revocation or
Mhm.
technical disbarment of paraprofessionals, what is needed to authorize that as a remedy for violation of, and that this is the big question, what's it a violation of? But I think it would be violations of the rules of professional conduct, or for practicing law beyond the scope here, as an example, what's needed to authorize that?
But I think Brady is right. Ultimately, the court would have to agree that that's the appropriate sanction. The legislature certainly can and has, for lawyers, adopted reasonable regulations where embedded within the statute, imposing a statutory obligation on lawyers is a recommended sanction of disbarment or suspension, and the court has respected that and adopted that. So it would be through the partnership between the court and the legislature, we would decide on whether disbarment is the appropriate term to use for revocation, or we want to say license revocation. I'm not sure anyone on the court has a strong opinion on that at this point.
Any other?
The only thing I would say that the court would, I think, have a strong opinion on being the final arbiter of that and making sure that any disbarment or revocation order comes from the court, just
Right.
as it does for attorneys.
Brady, I have some questions from them, if I can just go through them.
Sure.
So my overall question for all of them is, there's talk about probation, but then none of these actually include any probation. And it seems to me, I just want to make sure I'm correct. So maybe Carissa, this is a question for you too, is that it basically, you're looking at the top, you're looking at disbarment, actual suspension, and you're looking at the bottom of, what's the word, suspension or reproval. And so probation would basically fall in between those as you're looking at what actions you would want to take.
Somewhat. And so the recommended discipline wouldn't be necessarily you're recommending probation, but it would be a recommended discipline, and the attorney can be placed on probation. And some of these things that are in here might make more sense in the context of looking at kind of the rules of procedure for attorney discipline. And these rules of procedure is what would govern these proceedings in state bar court, which of course don't have to be mirrored for the paraprofessional program. And so perhaps there hasn't been a decision on whether we want to have sort of a probation program for paraprofessionals.
Although the concept was included in the discipline memo from back in February.
Okay. And just to clarify, Kim, sorry, I didn't mean to interrupt.
And I'm just doing this in the background for our next.
Okay, but Kim, so for attorneys, probation is not a form of discipline. So it's suspension with actual probation or suspension with state probation. But probation is not the discipline, it's the suspension that's the discipline. And probation is the manner in which it's imposed.
So you do it a little bit different. You do actual suspension, stayed, probation. Okay.
Yeah.
Got it. All right, that makes sense as to why they're like that. So just starting the definition for licensed paraprofessional, and this is like it is in the attorney one, but it says that it includes any agent of the licensed paraprofessional. Can someone just explain that to me? I mean, I'm assuming it's someone acting on that individual's behalf, but.
So Chris and I were discussing this, and it's intended to basically convey the concept that, and this is the same for attorneys, if an attorney accomplishes these violations by directing their staff person to do something, then the attorney is responsible for it. So this isn't, I know you could also read that as saying, oh, those people are now subject to discipline, but they're not, there's no jurisdiction over them. So it's that the paraprofessional, you know, when we say when a licensed paraprofessional does this thing, they're in trouble, that means if they or their agent, you know, acting on their behalf does that thing.
Okay, that makes sense. And then because it would also be aiding and abetting then too, right? If they were doing something beyond what they should be.
Right.
Okay. And then in 1.4, and again, it's just because I may not know the attorney field, it says make restitution or file a satisfaction of judgment. Just looking for, just so I can understand that the satisfaction of judgment, what would that be?
You know, actually, I'm not sure about that. If you know, this is 1.4. If this is considering a situation where perhaps the client already had an action against the attorney and a judgment against the attorney, and they would have to show that they paid that. If we need more specifics on how this is used, we can find that out. But if it doesn't make sense in this context, we can remove that.
I think it would, right? Because you could actually have a judgment against a paraprofessional if something happened, so you could sue civilly or.
Right.
Right.
Okay.
That's how I read it.
And then on 2.2, the word client is removed, and I just wasn't sure why. Because we have client listed in 2.4.
Sorry, guys. Trying to.
And maybe it's because they're not going to have a client trust account under a paraprofessional.
But they might. Let's see.
They might, right?
I think we are envisioning
Yeah.
managing a client trust account. Rule.
Was there ever
Rule
anything that would have
1.15.
is it being referred to differently than a client trust account, perhaps just a trust account? In that discipline recommendation memo?
1.15, is that what?
Yeah,
Point 15.
1.15 of the rules, right?
Talks about client, but.
So 1.15B as proposed refers to funds held in a trust account, but that is the same terminology used for attorneys. And then it just ends up being called a client trust account. I think this could, if it makes it more clear to say client, I don't see an issue with that. But I think it was removed to try to track that language from the 1.15.
Mhm.
Could there be another kind of trust account? I guess that's my question. If not, then maybe it's fine just saying trust account.
I think so.
Just gonna check one more thing here. Yeah, looking at this now, I don't see a meaningful reason for a distinction if we want to call it a client trust account. That might make it more clear.
Just
Um,
with attorney.
So I deleted, I undid the deletion of clients.
And then the only thing, I'm sure you guys did this, but I did not, so I'll be honest, and go back and look at all of the conflicts of interest sections. So in 2.5, I just wanted to make sure it's tracking with what the attorneys have, but did we add any when we were looking at any of those sections? I just didn't remember and just kind of wanted to mark it to make sure we didn't add any. Greg, you'd probably know if we added any special sections of conflict of interest other than the ones that are listed in those rules there. And that's my last issue.
No, we didn't. We didn't
Okay.
add any new conflict of interest rules beyond those.
Okay.
And when we drafted,
The one, there may be some that we should take out though. Let me just quickly look. Because 112 has to do with government employment.
so when we prepared these standards, it was on at the time, the draft version of the rules of paraprofessional conduct. And we looked, to make sure that these rule references were appropriate, but they may have changed in light of the recent recommendations made, but we could certainly review and update it.
Yeah, no, they're right.
Okay.
Yeah.
Thank you. That's it for me.
I think Fariba has had her hand up for a while.
Okay, thank you. I have, so in 1.2 E, is private approval not applicable to paraprofessionals? Is that the plan?
That was taken out.
Is that based on a discussion we've had and I've totally forgot, or was discussed in the discipline?
Yeah, that was adopted in March.
Okay, all right, got it. And then, all right, 2.5, I think my question was answered. And then I have some questions about the 2.15 and criminal convictions and let me go down there. 2.15. Okay, so summary disbarment is another section that was voted out.
So the summary disbarment is based on a State Bar Act provision specific to attorneys. So again, if we have some sort of similar provision created for paraprofessionals, we could consider that here. But at this time, it's just an attorney provision for the summary disbarment. It's a specific statute and a specific procedure for that. But Part B was left in because there is a rule of paraprofessional conduct that makes it a disciplinable offense for certain criminal convictions. So you can still get discipline for criminal convictions, just not the summary disbarment without the statute.
As to A and similar sections where you're deleting them now because, statutory limitations, right? And the statute has to be changed in order to include them. Are you kind of noting that, flagging them so that later it could be added? I think we talked about another section earlier.
For the legislature.
Yeah, okay. And then
we will have so it's all kind of complicated. We don't know what the legislature is going to do, but we do have a recommendation at the end of this on the memo for the interim disbarment to give that as a remedy.
Okay.
A remedy to the hearing panel for lawyers State Bar Court, but for here it would be the hearing panel to have an interim suspension as a remedy for certain criminal.
Okay, and then I see that felony was added here. So that felony is not included for attorneys in this section.
Basically,
Right.
responding to A.
Okay, so just moving it. Okay, got it. And then can you explain to me, and it's probably very obvious for everybody else, but 2.17 and then 2.18, they're all taken out. Is it because of a previous decision?
2.17 refers to sort of, I want to say obscure, State Bar Act provisions, again, that are specific to attorneys. So one has to do with specific to actually public prosecutors. Section B refers to certain claims for collusion, deceit, things like that. So again, just very specific to attorney discipline.
Okay, got it. Thank you. That was my list.
Amos.
Thanks. I just have a follow-up question, I think, to something Kim said, and it's something that's come up at prior meetings. I'm just not sure of the status. Is restitution an available remedy for a hearing panel, or is there something either that needs to be specified in these rules to make sure that is the case?
I think that's in our list of questions that we need to answer, right? In attachment B.
I don't think that's about restitution. I thought those were about more like sanctions and costs.
Oh, yeah, you're right.
Yeah, does restitution need to be called out in these standards?
Carissa,
So
how is it?
my recommendation is that restitution be an available remedy, and I don't know where that stood, so I don't know if the discipline committee has addressed that before, or if this is the time to do that.
Well, we have addressed it. I think we've been assuming that restitution is available. It's not a separate discipline for attorneys, right? Restitution is ordered pursuant to some other enumerated discipline.
That's right.
1.4, right?
And restitution very often is completing restitution is very often contingent upon reactivating the license. So very often when we order restitution to court, that's a condition for suspension.
Yeah, and I think there's some licensed professionals where that's the case and some licensed professionals where it's not. I would like that to be how it applies to or my recommendation is that is how it would apply to paraprofessionals. I just don't know if we need to specify that anywhere.
Does the section in 1.4 attach itself? It's up to the individual who is making the decision, but it's there, right? As it can be a condition.
That's right.
I brought it up, Amos.
I don't recall whether restitution was included in the February, March discipline recommendations. Do you?
I looked at it just now and I didn't see it there, Brady.
I was looking forward to and I did not see it.
You know, so it sounds like it is referred to in these standards. Do you want to make a separate recommendation that you know, just essentially however it's done, that restitution be authorized as a remedy for disciplinary violations?
So
Well, what
that
do you
would
mean
be
by
my
remedy?
recommendation. Oh, sorry, go ahead. So that would be my
I was
recommendation.
just wondering what he meant by remedy, because it wouldn't itself be a form of discipline. It's just
By
something
itself.
attached to discipline.
Yeah, so exactly. So that would have been my recommendation, Brady, but it sounds like what Greg is saying is that if we're paralleling what's happening with attorneys, that's not technically a separate discipline, but it is an authorized thing to be ordered.
Right. It's usually, it's classified as a condition of probation or reproval.
And as long as it's clear that that's possible for paraprofessionals, I think that's fine.
Okay. Just so everybody knows, this navigation does not seem to work while I'm sharing the screen. On 2.8, standard 2.8, the changes that I was making in the background were that the rule we realized as written, it didn't quite speak to 5.4. So, I mean, essentially what 5.4 now bans, subject to certain exceptions, is fee sharing with somebody who is not a lawyer or a licensed paraprofessional. So those were the changes that I made. So essentially now this reads that actual suspension is the presumed sanction for a violation of Rule 5.4.
Brady, should we change the title as well?
Right.
Yes. Anybody can think of a more elegant way to say this. Do I have disagreement with my plurals there?
It's hard to tell.
How about
We're not
people who
lawyers
are-
not lawyers or licensed paraprofessionals.
That's better, yeah.
So I don't know if a change is required because of 1.5 point. Well, the fee splitting is not allowed between a paraprofessional and an attorney in separate firms. Again, I don't want to make this more complicated than it needs to be, but that's something that's not covered here.
Other than the other violation of Rule 5.4.
Right, that would be a violation of now I'm forgetting, is it 1.5.1 or 1.5.2?
And that one might be generally covered under a different standard.
Okay,
That's kind of violations of the rules in general. So sort of anything not a specific violation called out in the standards would kind of fall, get lumped into, let me see which one it is, 2.19, which is violations of rules in general. So if there's a rule of professional conduct that's violated that isn't otherwise specified in the standards, it would fall here. And so if we think that violation of 1.15 warrants its own set aside standard, or something different, here it is suspension not to exceed 3 years or reproval would be the presumed sanction if it fell under 2.19.
that works for me. I just wanted to clarify, 1.5.1 is the fee divisions among licensed paraprofessionals and with lawyers, and it is allowed. What was adopted was that kind of fee divisions between paraprofessionals allowed, but it's not allowed for between paraprofessionals and lawyers. So it's a little bit confusing, but I'm fine with not making any changes here.
Julianne?
Yeah, I'm still confused. Is there a difference between fee sharing and fee splitting? There is, isn't there? If there is,
I would say no, there's not.
Oh, okay.
No.
But there is a difference between 5.4 and 1.5.1, and that the main difference there is if they're working in the same firm or
Mhm.
if they're in separate firms.
Yeah, so 1.5.1, you're right, Amos. That is covering fee sharing between, well, in this case, it would be between licensed paraprofessionals because that's all that's authorized. And there's a prohibition if they're not in the same firms. 5.4 allows you to share fees with a lawyer, paraprofessional with a lawyer, if they're in the same firm, because we've authorized co-ownership as well.
Well,
Right, so go ahead.
2.8, the title of the provision uses the term fee splitting,
It does.
but the text of it uses sharing. So you just might want to change one or the other to be consistent.
Is that a residual hand, Julianne?
Yeah, yes, I'm sorry.
No problem.
Residual.
So if there's no further questions, maybe we should move on to the separate issues. Do we need a vote, or do we just bring this forward as the submission from these committees? I think consistent with recent practice, we can probably just move them forward.
Brady, I sent you a text and maybe I just got it wrong. So citation and fine is not referenced here. Is that because on the discipline side, we decided it's not discipline? Does anyone from the discipline committee?
I know that it's not considered discipline, and maybe we should
Okay.
put that, because these standards, there's a prefatory language that says these don't address non-disciplinary dispositions like warning letters.
Okay.
Admonitions.
Okay. I just couldn't remember if we thought citation and fine was disciplinary, but okay.
Yeah, I'm almost positive. Look at that memo again.
Yeah, we said they're administrative.
Yep.
Okay. All right. Sorry.
And in terms of a vote, I think our practice has been if there's general agreement among
Right.
the subcommittees, we don't need to put it to a vote. We can just bring it to the.
Okay, so I'm going to start with my short one because those sort of go off these rules, Carissa, before we move to yours. If that's
Okay.
all right.
Yeah.
Let me see if I can. Okay. Does everybody see these additional issues? That popped up for everybody?
Yep.
Okay. So just two items that came up during our preparation for this this meeting. Number one is that, and correct me if I'm wrong, guys, I'm not sure that this has been considered by the disciplinary, the discipline subcommittee. In the rules for attorneys, the State Bar Rules of Procedure, there is one possible outcome is an admonition, and that's from the court. So here it would be from the hearing panel. But basically, the court may resolve a matter that's come to the court, State Bar Court for attorneys, if it doesn't involve client security fund matter or a serious offense defined as dishonesty, moral turpitude, corruption, bribery, forgery, perjury. That's all there in B. And the court concludes that the violations were not intentional or occurred under mitigating circumstances and no significant harm resulted. So this sort of provides an exit ramp from discipline, even once charges have been filed. And then another provision of the rule is that if within 2 years after that admonition is issued, the attorney recommits the same thing and there's another disciplinary proceeding, then the Office of Chief Trial Counsel can sort of reenact the initial proceeding that results in the admonition. And the question was, I went back and I did not see this addressed as a possible outcome, whether a similar outcome should be authorized for hearing panel proceedings for paraprofessionals.
For some reason, I remember talking about admonition, right, Julie and Ira? We did. I thought we chose not to do this.
I agree, Kim. I'm pretty sure we discussed this admonition and we didn't really like it because it's not public.
Well,
Yeah,
this, Carissa, correct me if I'm wrong, because there's an admonition that OCTC can give under, it's the rule right after warning letters. So we did include warning letters, right?
Right.
And then there's admonition, which is a separate thing in the rules that OCTC can do. And that, our understanding is OCTC just doesn't do it, even though it's allowed to. And this is a different kind of admonition that the court can do. And here it would be the hearing panel. And it's not non-public, right, Carissa, because it comes after discipline, a notice of discipline has been initiated.
Right. If it comes out of the State Bar Court, it would be a matter of public record.
But then if they do it, doesn't it go away? I think we had a question on this, like, does the charges stay out there?
It's essentially entered as a dismissal pursuant to like an admonition. So it does end up getting dismissed. But as Brady was mentioning, it's sort of subject to reviving those charges later if the professional reoffends.
I think we didn't want to include this because you guys were pretty consistent in just wanting to have fully transparent discipline.
Okay, and you're right. I mean, it's public. It's not confidential, but here the rule provides that the State Bar won't publicize it. So I guess it doesn't show up on your State Bar profile.
Right.
Okay. I mean, so I don't think we need it was just something that came up as we looked through this. I will make one change to the prefatory paragraph 1.1 says that this does not apply. These standards don't apply to non-disciplinary dispositions, including admonitions. So I will delete admonitions because we're not going to have admonitions. So that's the only action needed there. And then I also don't think action is needed here, but just, and again, maybe this came up in previous discussions, I didn't see it. There is a rule of court 9.20 that basically says disbarred, resigned, or suspended attorneys have a duty, and the Supreme Court may issue an order requiring them to notify their clients, to notify their opposing counsel, to return all their clients' property, and return unearned fees. And that, and this rule is referenced in these draft standards, in that the failure to comply with 9.20 can be a separate matter of discipline, and you can't, not doing so can be grounds for not being reinstated. And you know, I see this as more of an administrative issue, and that we will just highlight for the court, hey, you'll want to have a similar order for or similar provision for disbarment suspension of paraprofessionals. But I just wanted to raise that and make sure that that makes sense to everybody. So the thought would be that there will be a similar rule that when the Supreme Court orders suspension or disbarment, that they may also order notification of clients, notification of opposing counsel, return of money, and return of property.
It seems like they should to me.
Yeah. I
Yeah.
agree.
Okay. And then last is the second part of the memo. Let me share again. New share. And I'll let Carissa run through these since she expertly drafted them.
Sure. So this list here identifies some sort of open issues, things that exist in attorney discipline that I'm not aware that these have been discussed by the group. So just questions on whether we would want something similar for the paraprofessionals. So the first one is monetary sanctions. And anytime there's the imposition of certain discipline against an attorney, the discipline order can include an order for monetary sanctions, and those get deposited into the client security fund. So then the question, this is obviously something that is found within the Business and Professions Code, the State Bar Act, so wouldn't necessarily apply unless it's expanded. And so the question here would be if this one would want to be included essentially as an additional deterrent to misconduct, if we would want paraprofessionals who have this level of discipline imposed to be subject to monetary sanctions on top of the discipline.
Kimberly?
How often is this used for attorneys? Do you do this a lot?
Leah, do you recall? I think this is fairly recent. Is that true?
It is. I think it may have only actually gone into effect 2020.
Yeah.
I
So I'm not
think
sure
actually my understanding was that the statute has been in effect, but that the OCTC hasn't imposed it. And there was a directive to start doing that, including the monetary sanctions.
Yeah, we just we only adopted implementing rules very recently. And I don't know how many times it's done, Kim. And I also would say, when I mentioned earlier, there's a commission right now looking at our entire discipline system. Both sanctions and cost assessments are a hot topic right now. And I expect there will be some changes. But one approach might be for this group right now to just parallel what's happening on the attorney side, with the understanding that that may change, and then the oversight committee could consider conforming. But I don't know how often this happens.
So they could really have three things. So they could have cost recovery, they could have restitution, and they could have this sanction.
Yeah, and if everything has to be paid in order for folks to be reinstated. And so there's a lot of equity concerns about this, and the discipline costs themselves are quite high.
Was the point for monetary sanctions for attorneys to be a deterrent to misconduct, but also to make clients who have been defrauded whole through the client security fund? Was that the intent?
Well, the funding does go to the client security fund, but it doesn't go specifically to their client. So,
That would be restitution.
That would be restitution. Okay.
Julianne?
Yeah, I think I had the same question that Kim just did. So this is an additional remedy on top of citation and fine, which the discipline committee has recommended be included for paraprofessionals, even though it's not a remedy for attorney misconduct. And it's in addition to possible restitution. Is that right?
Although I guess wouldn't citation and fine not apply if discipline?
yeah, I'm not sure if citation and fine is not discipline. I don't think you're gonna get all of these costs. Yeah, you wouldn't get both.
And the sanctions, the monetary sanctions here are only if it's suspension or disbarment. So any lower level wouldn't be eligible, so to speak, for monetary sanctions.
Oh, okay.
Sorry. I'm in favor of including this. And I also wanted to point, I just looked up the statute and it was effective January 1 of 2019. Maybe there's a predecessor that said the same thing, but I don't think so.
I also like the idea of just tracking the attorney rules for now, so including this.
Yeah, I could say consensus,
I agree as well.
follow attorney approach.
The only thing that's a little bit different is the amount. I don't know if I mean, it's probably going to be moot, but it's pretty high for what we think paraprofessionals are going to be doing. But that was my only thing I had thought about.
It's a ceiling.
If it's going to change, though, we could I'm fine with it just as it is. That was my only concern that I had.
I think a lower ceiling for the per violation, but maybe not for the total, because there could be a whole lot of violations.
So what's the thinking before a lower sanction? Because if they're practicing law and they're doing the same thing as an attorney within their license, and they do something that is misconduct that's subject to being disciplined at this high level, why would you think a lower sanction might be appropriate?
Yeah, I have the same question, especially because we don't have pre-caps at this point.
Well, because they're by and large, very large, going to be dealing with client matters that are worth far less money than lawyers do.
Right, but their misconduct can cause just the same level of harm.
Well, can it? I mean, isn't it likely that a lawyer's misconduct is going to cause a lot more financial harm than paraprofessionals?
But sometimes you're dealing with non-financial issues too.
I know, but
family law or in housing law. No.
yeah.
I think this should really mirror what we're doing for attorneys, and I don't think that it should be any less.
And like I said, I do think that changes are coming because there's a reality here, right? Even for attorneys, at some point you load up sanctions and costs and people aren't paying. All it is uncollected debt. So I think, if changes come on the attorney side, we'll be well positioned to implement them here.
I like this more as a deterrent than a source of funds. It's harder to get your hands on the money, but if it serves a purpose as a deterrent to not even get to this point, I like it.
I agree for you both.
Okay, are we ready for the number 2?
So let me just to make sure the consensus is still follow the attorney approach. I guess with the general understanding that it could be revisited.
I'd say, yeah, that's the consensus. I don't even
Yes.
feel that strongly in my statement against it.
Okay. Next.
So this one's similar. It's kind of tied in the idea that certain levels of discipline can require an attorney to pay costs, which of course include actual expenses of the state bar. So similar to a lot of the issues discussed for the monetary sanctions, this is something that would want to be included for the paraprofessional program. Julianne?
So Carissa, this particular rule here, as you have cited it in A, is applicable to attorneys?
That's correct.
I just wanted to point out that over in DCA world, Kim, correct me if I'm wrong on this, Business and Professions Code section 125.3 governs what is referred to as cost recovery over in that world. And the cost recovery statute specifically precludes the recovery of costs for the hearing and review, meaning the licensee can be assessed reasonable cost of investigation and enforcement up until the first day of the hearing. After that, it's cut off. The idea being that if you charge the licensee for the cost of the hearing, you're chilling that licensee's right to request a hearing. So I guess if this applies to attorneys, that's one thing, but I wanted to point that out, that over in the rest of the regulated profession world, costs are cut off at the first day of the hearing.
Thanks for raising that, Julie. I'm just sending that a note to the staff person, the lead staff person on this discipline commission I mentioned, because we have a couple of DCA folks, Kim, on that commission. I don't know that they've raised this with us yet.
Who's on that, Leah?
Oh, I'll look it up. It's someone retired and somebody, it might not be DCA, it might be the medical board. I'll look it up.
This was litigated all the way up to the California Supreme Court in a case, just the general constitutionality of this cost recovery statute was litigated in a case, I believe it was called Zuckerman. And it had to do with the Board of Chiropractic Examiners, but it challenged the constitutionality of 125.3, which the court upheld, but with some tweaking and limitations. So you might want to throw that at them too.
Okay, yeah, it's Linda Schneider, Kim, and Jenna Jones from the medical board.
Yeah.
Well, so Jenna's on that. Yeah, Jenna's a little bit new to the medical board. Maybe a couple.
But Linda Schneider, she's a deputy AG, right?
Oh, that's who I was like trying to figure out. Linda Schneider, I know that name. Yeah, she used to be a SAG, right? Actually.
I believe she was the head of the licensing unit.
Yeah. Mm-hmm.
And she'll be very familiar with this.
Lest we digress, thank you for bringing that to our attention.
Yeah,
But I agree, it is chilling. It's a reason not to do it.
I think we should not do it. I think that should be our recommendation. Or if it is,
I would support that too. So it's a little bit of a change rather than just following the attorney standards, but I think that's the better rule.
yeah.
Can you sort of spell out what the recommendation would be?
It would actually be removal in that A, I think, Brady, of the cost for transcripts and reporter services.
So I wouldn't remove it from A because that is the attorney rule. I think
Right.
we're changing that.
Oh, I see what you're saying.
So I think we would just change C to limit it.
Right.
And just for the transcripts and reporter services?
Well,
Sorry,
I think not, because it says these costs include,
Right.
it could be more, so how about saying something like, the costs shall not include any costs incurred once the hearing begins. It's not well said, but you know what I mean.
Julie, do you still have 125.9 up? Because it might be good just to kind of mirror that, because it's really just the cost of investigation and prosecution.
Well, whoa, does it say prosecution? Because that,
No, it does say that, but the Zuckerman case defined or interprets it. It's 125.3 actually, I think.
Civil code?
Business and Professions Code, sorry.
At 0.9, I think it's citations. I think you're right.
Right.
And but the general idea is up to the hearing, and it would not cover the costs of the actual hearing or trial, right?
Correct.
So in the statute that this issue was raised from, it would require, under that statute, the cost would be the actual expense incurred by the bar for the original and copies of reporters' transcripts and any fee paid for services of the reporter, all expenses paid by the state bar, which would qualify as taxable costs recoverable in civil proceedings. The charge is determined by the state bar to be reasonable costs of investigation, hearing, and review. So it sounds like the hearing and review is the section that would need to be removed if we were kind of paralleling this State Bar Act provision, right?
how about investigation that takes place before the hearing commences? Because it might, there might be some while the hearing is going on.
The language of the statute 125.3C says the costs shall include the amount of investigative and enforcement costs up to the date of the hearing, including but not limited to charges imposed by the Attorney General. So
Investigative and what costs? I'm sorry.
investigative and enforcement costs. So that not only includes the cost of the investigation, which is usually borne by the licensing agency, but also the enforcement costs incurred by the Attorney General in assisting that investigation or deciding what to do with it. And I believe that sentence is interpreted specifically in that Zuckerman case that I referred to. It's a California Supreme Court case.
And I think the context for the Attorney General cost there in licensing is the licensing board often does the initial investigation, but at some point it's the Attorney General's office who takes over and actually does the enforcement proceedings. So there could be some additional investigation costs by the Attorney General before, a formal hearing.
Well, doesn't the Attorney General, in effect, bill the consumer agency for the work of its lawyers even?
Yes, yeah.
All right,
Yeah,
so
but for these purposes, what I'm explaining is why in the context of the licensing boards, the costs are coming from two different places, but they're all still investigation costs.
Which we don't envision here, at least.
Exactly.
Now, I'll take a look at I'll come up with better language. I'm just trying to make sure we have the concept here, unless. Does that reflect the consensus? Basically, yes, but make consistent with 125.3.
why is it the date of the hearing? In other words, when is it that we're talking about trying not to chill something. So when does the paraprofessional's decision to go forward with something with the hearing or something that results in it, when does that take place? That seems to be the key point.
Well, who knows when they make the decision, but I guess that's when the costs
What I
escalate.
mean is, what is the decision? Is it the paraprofessional's decision, or is it only for paraprofessionals? In other words, does the paraprofessional at some point decide, yes, I'm going to go forward with the defense and that'll result in a hearing? Or is it just a matter of the paraprofessional defending a hearing when the prosecution, if you will, decides to go forward?
So as I understand it, the public policy that we're trying to implement here is to not saddle somebody with the presumptively very expensive costs of taking something to hearing that would
Yeah.
be incurred by the bar or whoever's bringing the case. But not, we're still allowing the investigation. So prior to the hearing.
What I'm
It's
thinking
not
of
about the
is,
decision.
sorry,
It's
go
about
ahead.
the cost. So just to be clear, it's just a public policy. There's different ways to approach it, but I think what's being suggested is follow the approach in other administrative hearings where you don't chill by potentially including very significant costs incurred during the hearing. But we still want to include in recoverable costs the cost of the investigation.
Yes, that's why I think the word enforcement doesn't belong there in the last line. It's the investigation. Costs of investigation.
I think that word Ira was used because we already have investigation, and enforcement was the part basically for, I think Brady's going to have to rewrite this obviously to mirror more of what the state bar does, but enforcement for like DCA is the AG's piece of it, of them prosecuting the case. So it will be different because you don't use the AG's office. So, but that's the gist of it. And Brady, I think you're just planning to rewrite it, right?
Right.
Okay.
Well, it's not the AG, I guess I don't know who it is. It's the state bar who will be, yeah, it's the state bar who will be doing the enforcement. So it seems to me we don't want it under this principle of not deterring. We don't want to include enforcement costs. We do want to include investigation costs.
I mean, isn't another way to say it? We're doing 6086.10, but we're cutting it off at the hearing date.
Correct.
Yes.
I didn't
And
think
all this other stuff we're just saying it's consistent with that approach.
Correct.
that I don't know if that's not clear in my mind, because it seems to me that there's things that happen before the actual hearing date that are things that we don't want to impose as costs that the paraprofessional has to pay because they're things that happen in connection with the hearing. In other words, the state bar lawyers are going to be probably going to be doing a lot of work before the actual hearing date, getting ready to prepare for it. A lot of work. And
How about the costs? We could exclude costs related to a hearing. Rather make it the date, make it related to
that's better.
preparation.
In my mind.
In preparation for costs incurred after the hearing date and costs incurred in preparation for the hearing.
So just to be clear, I don't agree with the distinction, because
Okay.
or it's a distinction that without a difference, because what at least the attorney
Everything's-
licensing says, if you're assigned a case, you're working it up.
Yeah.
And you're going to call investigation versus enforcement or preparation for hearing. I don't think there's any real distinction.
Well, what about when the attorney writes the is it a complaint, whatever it is that
It's
goes?
the notice to show cause or whatever it's called now.
Okay, so that's not the investigation.
Yeah,
But
so
it-
I think it's the cleanest way to do it, I think, is to follow what's done in the administrative hearing, is just to have a date. So it's just a bright line, because these other distinctions, I think, are just, I actually don't think they make sense, but they certainly would be ambiguous.
Well, to me, if it says cost of investigation, that's best. cost of investigation up to the date of the hearing.
I think
That's
the
pretty-
intention is to again, that deterrence that we were talking about. And that's why you include the prosecution, because that is part of it. It's not just that they're getting investigated, but now they have costs, their licensing board costs for the fact of the prosecution of this case, whether it's called, on your side, but for them to put together that notice of charges. And again, if you don't pass that on to this individual, you have all of the other paraprofessionals paying for this, what this individual who has violated the law. And so that's why you do all those charges. But to that degree, they've said, we don't want to deter people from choosing to go to hearings, so we're not going to include those costs. So that's why, in my opinion, I think you should include both investigative and up until the point that the hearing is set.
Well, I don't agree, and because to the extent that we're trying not to deter some decision or other, or maybe several decisions by a series of them by the paraprofessional to defend the case. So some of those decisions will take place, I think, I haven't reviewed the procedure in quite a while, but I think they will take place a good deal before the date of the hearing.
So I think people understand what you're saying, but are challenging both the workability of that standard and to Kim's point, where you're striking the balance between having not everybody pay for discipline costs versus not chilling. So I think maybe we should I don't know what the procedure is, but make this a split decision.
Okay.
I think that's a good idea, so we can move on. Are you clear on what the split is, Brady?
It's between Naira. I understand everybody else's position, but yours is to somehow limit, in principle, the costs that can be imposed to just investigation costs, or
Investigation up to the date of the hearing.
just investigation costs.
Yeah. I'm not even positive that's the right, I'd have to study the thing again, but for now, that's what I propose. It's like a boxing match.
All right, let's move on to 3. Carissa?
Yes, so these refer to conviction proceedings in the state bar court, which is sort of a set of special proceedings that have been developed within the state bar court. Something similar could be mirrored for the hearing panel or the appeals version of that. And essentially in the State Bar Act, anytime an attorney is convicted of either a felony or a misdemeanor that involves moral turpitude, these provisions allow the state bar court to place that attorney on suspension until the period for appealing that conviction has concluded. After that point, it can go 2 ways. If it's the run of the mill, so to speak, felony or misdemeanor involving moral turpitude, the state bar court proceedings allow for a hearing for the attorney, resulting in possible discipline, which would either be disbarment or suspension of some sort. The other way that this can go, and I'm sorry, there's a typo here. I refer to subdivision B. It's actually subdivision C of section 6102, provides for submarine disbarment of an attorney following certain felony convictions. And those convictions include crimes where an element of the offense is the specific intent to deceive, defraud, steal, or make or suborn a false statement or involved moral turpitude. And then part 2 of that would be the facts and circumstances of the offense involved moral turpitude. So those would be the specific crimes where the conviction of that crime would provide the ability to summarily disbar the attorney. And so these are, like I said, it's like a specific special proceedings that have been developed to handle these criminal conviction matters. And whether we want, whether you want something like that for the paraprofessionals as well. There's kind of a lot here, so if you have questions, I have the statute pulled up and I can try to address them.
So Carissa, is it really, it's two things. It's number one, the suspension, and then number two, whether, and we discussed this before, we'd want a recommendation for a summary disbarment.
Right, so the idea that once they're convicted, they can kind of automatically be placed on suspension just based on that conviction, with, of course, discretion for the court or the hearing panel to not impose that suspension. But that's issue number one, sort of an automatic suspension for once you're convicted. And then yes, part two is the ability to summarily disbar for certain offenses.
I'd be in favor of this. I don't know why we wouldn't do this.
Me too.
Yeah, it doesn't sound like there have been anything identified that it shouldn't be expanded for paraprofessionals, right? So again, tracking the attorney rules, I think, would be the best approach.
I agree.
Agree.
Yeah.
Too. I'm envious of it.
Okay, next four. We're almost.
So number
Carissa?
four is, yes, it's subsequent arrest notification. So this is where attorneys have submitted their fingerprints to the Department of Justice. Those fingerprints are retained to allow subsequent arrest notifications to be provided to the state bar, obviously anytime the attorney is arrested. And this goes hand in hand with the criminal conviction proceedings. What we do in the attorney world is that the state bar sets up kind of a monitoring case where, okay, the attorney's been arrested, we're informed that the attorney's arrested. Now we can monitor that until the attorney is convicted and then institute conviction proceedings. So then the question is just, would the paraprofessionals be subject to the requirement for the subsequent arrest notifications based on their fingerprinting?
And
Yes.
to be clear, yeah, and to be clear, I think this statute would be necessary for the state bar to collect the information from the Attorney General's office. So I would support this as well.
Yeah,
Me too.
me too.
Same here.
All right, next, Carissa.
So this one refers to the involuntary and active enrollment sort of special procedures that the state bar court has. Actually, some of these are the state bar is required to place attorneys on involuntary inactive status, sort of based on if they've been involuntarily, ordered to undergo involuntary treatment, they have to go inactive. And then in other circumstances where there's a state bar court proceeding, they can be automatically placed on involuntary inactive enrollment for various bases that are listed out here. And they typically arise from either the mental or physical inability to practice competently, or where their conduct presents a serious threat of harm to the public. So I've listed them here. They all come under Business and Professions Code 6007. And one thing to note here, in the state bar court where an attorney is subject to these proceedings, they are entitled to appointment of counsel to represent them. And if there's any questions, I mean, I know there's a lot here under these, but it's essentially any of these four reasons: insanity, mental incompetence, defense, assumption of practice where the court has has the authority to assume an attorney's law practice for various reasons. The attorney has mental illness or habitual use of intoxicants that affects their ability to perform competently, and then where there's a threat of harm to the clients or the public. And it's likely that the Office of Chief Trial Counsel will prevail in a disbarment proceeding. So any of these would allow the involuntary inactive enrollment.
So this is not for an indefinite amount of time. It's just temporary until there's a decision that's made.
Correct. And it could be that there has to be kind of a certain showing that whatever it is that led to the involuntary inactive enrollment is no longer a problem, essentially.
And here I think that what we'd be looking for is just a agreement from the working group that this concept should apply to paraprofessionals as well.
I don't see why we would not apply this to paraprofessionals.
I agree, Julianne.
Agree.
Me too.
Yep.
So the misconduct in another jurisdiction is essentially a final order of discipline in another jurisdiction is conclusive evidence of culpable misconduct for a California attorney. And these are expedited proceedings. The only thing to note here is this paraprofessional model is not common in other jurisdictions. Not that it couldn't be adopted, that we could have discipline based on misconduct in another jurisdiction. But essentially that's the question here. If it's even worthwhile to implement those procedures
Yeah.
yet.
My vote would be to put them in now.
Yeah, me too.
I agree, this should apply.
Okay, number 7 is a rule of limitations, which is currently in the rules of procedure for attorney discipline matters. And it prevents the state bar from instituting proceedings beyond 5 years from the date of the alleged misconduct. It wouldn't prohibit discipline that arises from another source, whether it's a state bar initiated investigation, the conviction proceedings, that type of thing. But it's just if it's based on allegations from a complainant, those charges have to be brought within 5 years. So the question here, is to include that or not to include that. For what period? Would you want 5 years or less, more? And then in the attorney model, there is a list of tolling provisions that would allow for tolling of that rule of limitations. Happy to go through them if anybody wants to know what they are. And so would those same tolling provisions be included here?
Can you give us some examples of the tolling provisions?
Sure, let me pull that up.
You want to share that, or I can pull it up and share it?
Sure, it's rule of procedure 5.21. That might be easier. Just put it up on the screen.
While you're pulling that up, is this from the date, so you get the complaint until the date the charges are filed, not the final outcome, right?
So it is based on when the charges are filed, but it's not based, it doesn't start running on the date the complaint is filed. It starts running on the date the misconduct occurred. And so some complainants, for whatever reason, bring their complaint very late. Sometimes they bring it after the 5 years. So their attorney engaged in misconduct 10 years ago in their criminal conviction, or rather their criminal defense proceedings, and the client doesn't bring the complaint for 10 years. Well, it's already past the rule of limitations. So it's based on when the misconduct occurred and when the proceedings are instituted, no more than 5 years.
Occurred or discovered, or
Yeah.
just occurred?
there is a provision, it's when it occurred, not when it was discovered, but there is a tolling provision for if the attorney concealed the facts that would.
And it's told during the representation. So that's also a key one.
Right.
So I recall when Ryan Jorbin testified before us, she said something regarding this, and I'm trying to remember what it was, but like maybe it was something towards that the tolling should happen when it's discovered, not when it actually occurred, because sometimes you're not, I guess like as a client, you're not aware that it happened, and then precious time passes by. I don't know if others recall that.
I do. In fact, one of the joint recommendations from discipline regulation coming forward around UPL has to do with extending the statute of limitations. I just don't know if this is the particular statute that's being referenced.
I think that's exactly right. So the joint recommendation based on what Sharon's talking about, the testimony, was for criminal conviction, for criminal charges, that there should be a discovery rule as a tolling. So, but I do think this is parallel for state bar discipline.
You know, one recommendation could be that that a tolling a limitations period for complaints against paraprofessionals, you know, similar to that for attorneys and set forth in Rule 5.21, be established with the exception that the limitations period begins running when you know the misconduct was discovered or should have been discovered by the complainant, something like that. So we sort of adopt the attorney approach, but make the modification.
I'd be in favor of that. I'll just clarify for statute of limitations purposes. I actually think it might technically run from the date of misconduct, but it might be a tolling when it hasn't been discovered, or tolling until it's discovered. So you might look to see how those discovery rules that are thought of are typically, if it doesn't actually start the running of the statute, or if it's just a tolling of the statute.
I'm in agreement with Amos.
Just as a point of reference for ours, at least ours are all over the map for our boards and bureaus. They're all different, but the medical board one, which is kind of, some are similar to this, is that it's 3 years from the date the complaint is received, or 7 years from the date of the misconduct, basically, whichever is first. So then you have two. You have, you know, from the date the complainant sends it in, but then you also have a little bit longer, obviously, from the time of the event. And we have exceptions to the, you know, and one I didn't see on the rules here, I don't see one for, and maybe this is just because of the difference, but like for ours, for sexual misconduct, we extended that out because on those, sometimes you have individuals that don't come forward for a long time to talk about that. So I don't know if that's something we want to consider.
So kind of interesting. It's shorter from if a complaint is actually filed, so that you make sure that is the complaint process is forwarded expeditiously, or at least reasonably on a timely basis, because at least a complaint has been filed, versus if it's not even been discovered, it gives the client a longer time. I kind of like that difference in time versus just a flat 5 years from either date. What does everybody else think about that differentiation?
Yeah, so a main point of a statute of limitations would be to, you know, fairness to the person accused, so that it's not held over their head forever, that there is some time. But the flip side of that is if the client doesn't know that, you know, so I think it's really just a different way to attack the same problem, either a discovery tolling of the limitations or just a longer period of limitations are two different ways to address that, I think.
I'm okay with how it's written right now.
due and complainant.
And I think that is consistent with our recommendation, the parallel recommendation of this joint group for, the criminal remedies or UPL or other remedies for criminal cases.
Okay, and I think we've come to the last one with 2 minutes to go.
Well, we have one other
Something
item.
else. Yeah, I know.
We have, one other item. So let's, hopefully we can get through this quickly.
So this just speaks to appeals for closed complaints. So where a complaint doesn't result in a disciplinary charge and gets closed. In the attorney world, the complainant can seek review within the state bar. It goes to the Office of General Counsel in the complaint review unit rather than staying in OCTC. And then from there, if that complaint remains closed, the complainant can seek further review from the California Supreme Court through an accusation process. So I assume there would want to be some sort of appeal, but the question would be by whom, or would it be to skip the appeal entirely and seek review directly from the California Supreme Court? I would think not, but that's the question.
I have some memory that we addressed this in our procedures, but maybe we didn't. You look at that chart.
This is not appeal by the paraprofessional, Ira.
Yeah.
It's appeal by the complainant. It's really just the process that complainants can go through if right now, if the Office of the Chief Trial Counsel closes their complaint. So I think we would want to have something parallel.
And I think we did talk about this. And I think we wanted this to happen, and I just can't remember who we wanted to review. Obviously we won't want the board because there'll be an outcome. I don't know why we can't. Can we just use the same group as the bar does?
You can certainly recommend it.
That's the group you're talking to right now, Kim.
Yeah.
The
Oh, that's
Office of
great.
General
Then let's use
Counsel.
it.
And it would make sense because it's going to be a very similar process.
I'd be in favor of that. And I do recall that we discussed this.
And our apologies, we were reviewing sometimes not all the videos, and I've been on some of the meetings, but more the recommendations. So if it was discussed, we just didn't catch it.
I think we should adopt the same process for paraprofessionals.
Yeah, me too.
This is obviously my notes, and I'll be writing this up to share with the world. All right, I think that is it from Carissa and I. Thank you all for getting through a lot with us very quickly.
So I'm hoping people have time to stay on for a little bit longer to talk. It should be pretty quick. Let me just share with you. So just as a reminder, the discipline subcommittee reviewed the question about what records would be public and whether they would be on the website or not. And the one outstanding issue is the one on the bottom of the screen here, having to do with criminal convictions. And you asked us to look into how this is handled for attorneys. So this is the process. So as you can see, felony charges, if just the charge is not necessarily conviction, there's a consumer alert that goes up on the attorney's public profile. For a criminal conviction, the record is transmitted to the state bar court. And I think we talked about this, what the process would be for criminal convictions for paraprofessionals. And the record of that transmission, even before discipline is imposed, shows up on the public website. And I have like screenshots that show what that looks like. So this is a consumer alert for felony prosecution. And this is what it looks like when the criminal conviction is transmitted to the state bar court. So I don't know if you want to mirror the process that we have in terms of what records are public and at what point that they're public. If you want to talk about it a little bit.
Does it have anything to do with the nature of the crime with regards to the misdemeanors?
So as I can go back, there's, for misdemeanor, it's almost everything gets transmitted. Almost everything. There are some misdemeanors. So if misdemeanors that don't have anything to do with the practice of law and don't involve moral turpitude don't get transmitted. So I think like first time DUIs might not get transmitted. But my understanding, a review, and I was talking to Justin Ewert, who's been on some of these calls, and he's staffing the ad hoc commission on the discipline system. So he's looked into this. He said there's even been like misdemeanor trespassing convictions that get transmitted. So almost all the criminal convictions get transmitted.
Do you know specifically about DV related misdemeanor DV, was pled down to disturbing the peace? You don't know that much detail, do you?
I don't know that much detail. I know that whenever the bar gets notice of charges filed against, of a conviction, that's reviewed and a decision is made about forwarding them to OCTC and having them transmitted to state bar court. But my understanding is that it's very, very rare for a conviction not to be transmitted.
Okay.
Linda, so you need a decision on whether we believe that these should be posted. I think that alert is really good.
Yeah, so basically we want to fill in this table for the criminal convictions.
Okay.
And also for felony charges. I think that's something that's not even on this list, but I think we would want to add that.
I think this should mirror what is being done for attorneys.
I agree.
Yeah, me too.
Okay.
Same here, with the assumption that definitely any type of crime, even misdemeanor that's related to veracity and honesty, those are the types of crimes that are definitely going to be reported, even if misdemeanors. I'm assuming that that's true.
Yes.
Okay.
And we're better before we did the re-fingerprinting and we're getting these subsequent arrest notifications. We were relying on the courts to advise us. Attorneys are supposed to advise us if they've been convicted of a crime, and we were relying on the courts to do that. Now we get a notification every time there's a criminal conviction.
Good to know.
I think there is a process for expungement, or at least for misdemeanors, a certain time period. So I don't know if that needs to be addressed now, but I agree following the attorney rules makes sense. And it should be, however that's dealt with attorneys as well.
Okay.
Yeah, I agree.
Okay, great, thanks. I don't think we have anything else. So I think this is the last meeting of this subcommittee. We have our meeting on the 31st and we're working to get all these recommendation memos ready for the working group for our final consideration and to include them in the report. But thank you all for these two groups have just been put in so much time and so much thought into this process, and I want to thank you.
Jeans.
Yeah, and
Thank
the
you.
staff too.
Thank you.
You know, I
Gonna
really
say,
appreciate
yeah.
all the work OGC and also Greg, your involvement. It's been really great. Thank you.
Thank
Nice
you,
to see a
guys.
light at the end of the tunnel.
I know, I can't believe it. I don't know if you guys saw some of the draft report sections Linda sent out. We only have 2 more meetings. Shocking.
Well, thank you,
right.
Leah, for
Thank you.
Thank you for your
Thank
hard
you.
work.
Thank you.
Okay, bye.
Bye, everybody.
Aye.
Hey, Linda.
Yeah.
So I will do.
Hold on
I
one
guess-
minute. Let me just
Stop recording.
stop recording. Hold on a second.